Hello everyone, it's really lovely to see so many people signed up to the NHS Providers 2022 Governance Conference. There's lots of meaty topics being discussed over the 3 days, so I hope you'll all enjoy the sessions. To give you a very brief intro, I'm MacIntyre and I'm the Director of Corporate Affairs at Mid and South Essex NHS Foundation Trust, and I'm also the co-chair of the Company Secretaries Network, and I'll be chairing our session today. Our presenter today is Michael Rourke, and he's a partner in the corporate commercial team at Hempsons Solicitors. Michael and his team work with providers and commissioners across England, advising on a range of governance, regulatory and commercial matters. This has included advising a number of CCGs on the forthcoming transition to ICBs and provider collaboratives on partnership arrangements. So in terms of how this session will run, Michael has prepared a presentation on what is currently known about conflicts in the new systems, and then we will open up the floor for questions and discussion.
So that straight over to me, is it, Lauren?
Over to you,
okay.
Yes.
Good morning or good afternoon, everyone, and thank you for joining this session on conflicts of interest in within the new ICS systems and how to manage them. We are well and truly underway now with the Health and Care Act having received royal assent a short time ago. And for anyone who's a real watcher of legislative change, the first parts of the Act came into force yesterday, making minor amendments such as changing the legal identity of NHS Commissioning Board to NHS England, but only for the purpose of interpreting the new provisions as they come into force. Essentially, the Act is not yet in force, but has passed, and so we are on the journey to ICBs and the new integrated care structures. In my short presentation, I'm going to discuss the state of knowledge now, and I'm afraid I'm going to have to speculate a little bit about the future. I'm afraid all is not as clear as it might be, but hopefully things will become clearer before the go live date. So can I move on to the first slide? So as I think everyone will be aware, in fact, I can't imagine anyone in the health system being not aware that the new Act is amending the existing legislative framework, introducing integrated care boards, which will be largely the commissioning function for the regions over which they preside. One small, I suppose, benefit is that the Act's provisions on conflicts of interest are essentially the same as for CCGs. So there will be a lot of inherited knowledge coming across from the movement of staff and governance individuals from the existing CCGs into the ICS body or the ICB. But I would say that this is a developing area and we do anticipate, I'm afraid, challenges ahead on a practical basis, deciding what to do when conflicts arise between the members or on decisions in front of ICB panels. And in terms of potential legal challenges in future, where those who are not content with decisions that have been made by the ICBs, potentially bringing judicial reviews on the usual grounds of failure to consult or failure to appropriately take into account matters such as the Equality Act, but also on this area of conflict of interest and whether those who've made decisions were the right people. Next slide, please. So in the changes to the 2006 Act, we have, I'm afraid, the sort of section numbering that gives lawyers a bad name. But the snazzily numbered 14Z30, the new provision, is where the meat of what is required for ICBs concerning conflicts of interests is found. So the basic provisions are that you must maintain a register of interests for the members of the board, members of the committees and subcommittees, and the employees. As with CCGs, the registers must be published or right of access given to members of the public. So in most cases, they'll just simply be put onto websites for people to look at. As with CCGs, the 28-day requirement to declare a conflict of interest once known to a member is also being incorporated. Next slide, please. So the 14Z30 requirements are supplemented a little bit in Schedule 1B with some provisions on the Constitution, but essentially the requirements are that you have to have and make arrangements to ensure that conflicts of interest are declared within 28 days, and making arrangements to manage conflicts and potential conflicts of interest in such a way as to ensure that they do not appear to affect the integrity of the board's decision-making processes. I think that's the key sentence in the Act, or the key part of the concerns that are being raised, as how can potential conflicts of interests not appear to affect the integrity of the board's decision-making processes, given the individuals and bodies represented on ICB boards will inherently have interests within the systems for which they are making decisions. The requirement is that the Constitution for the ICB sets out the arrangements and a statement of principles for implementing the arrangements. All ICBs will have the template Constitution provided and drafted by NHS England and currently being finalised in the different regions, and all of these points are incorporated within there with the drafting notes and explanations. The change, I think it occurred in the drafting of the passage of the Act, was a prohibition from appointing a person as a member if they considered that the appointment could reasonably be regarded as undermining the independence of the health service because of that candidate's involvement with the private sector or otherwise. A fairly broad prohibition on potential conflicts with the independent sector from becoming a board member. And certainly it reflects the concerns, which are probably more political than reality of the ever privatisation of the NHS. I'm not entirely certain that ICBs were proposing to appoint individuals from outside of the core NHS bodies, primary care and council, to the ICB boards at this stage, but that prohibition indicates that will not be an area that will be an area that will scrutinised if others are appointed to substantive posts. Next slide, please. So the important point to bear in mind is that conflicts of interests are not new to the NHS and are not something that hasn't been dealt with before, either at individual institution or CCG level over many years. The Constitution guidance refers those drafting the constitutions to the NHS England's guidance on managing conflicts of interest, last updated 2017. This doesn't technically and won't technically bind ICBs, but the guidance that has been published indicates that it should be paid attention to by ICBs, and there's a potential for additional guidance or this guidance to be expanded to it. But I think the key line I would take from it, and I'll explain why, is that the conflicts of interest are unavoidable in complex systems, and the NHS is an incredibly complex system. However, avoiding conflicts of interest or substantive conflicts is also important for what I will refer to a bit later as the sniff test in my summary. Can I move to the next slide, please? I've said what is a conflict of interest a number of times. We should probably set out what a conflict of interest is, and the definition in the slide there is the one set out in that guidance. This is what NHS England has used for a number of years now as the definition of a conflict of interest. Effectively, if a reasonable person thinks that your ability to make a decision is impaired by an interest, either financial or otherwise, that you hold, you should not be involved in the decision-making process. The next slide, please. Within the guidance on conflicts of interest, I think the most interesting and readily apparent applicable type of conflict is loyalty interests. That's where people put the interests of an institution or organization in front of the regional interests or system interests. The operating in a silo is perhaps the wording that's been used over a number of years, rather than collaborative and group and regional decision making. Importantly, within this guidance on conflicts of interests, to which ICBs are directed, is that the knee-jerk perhaps reaction that any conflict or any decision you should immediately excuse yourself is not the default that is recommended in complex systems such as the NHS. It's expressly put out in the guidance that the default guidance should not always be to exclude members from making decision makings, as that could be detrimental to the decision making process. Can I move to the next slide, please? So a more recent guidance specifically directed at ICBs was published last year in August, which set out NHS England's thoughts on where ICBs should be going with the development of the local ICB constitutions and interests. I note that the section 14Z51 requires NHS England to publish guidance on discharge of functions. I also noticed that the current guidance is called interim guidance. I'm afraid I don't have an inside track to tell you whether new guidance will be published or when it will be published, but there's a firm hint that we will see a swathe more guidance coming out from NHS England on the operation and substantive operation of ICBs, and hopefully that will give further guidance on issues such as conflicts of interest and how to deal with them. However, as noted in the previous guidance, where the default position should not be simply to exclude members who may have an interest, this guidance, the interim guidance, repeats that and states that the individuals involved are expected to act in accordance with the sort of regional principles, and it should not be assumed that people are professionally or personally conflicted simply because they are a member, director, partner, or otherwise hold a position within one of the organisations represented on the board itself. Next slide, please. The further points that come out about not having simply a policy of must not be involved is that these decisions need to be proportionate, and that a distinction needs to be made between informing decisions and decision making. And I will give an example in a moment of an area where decision making will be rather more complex than general. But those involved in informing how decisions are made would be rather broader than those who necessarily take the actual decision, with the involvement of third parties or people who may be directly affected in informing how those decisions be made and providing information. Excuse me. The guidance is quite clear that decision making could be poorly affected if a knee-jerk removal or exclusion of any potentially conflicted individual was sorry, someone tried to call me as I rang, so that's kind of unfortunate. That removing people knee-jerk, you'll lose the information, understanding, and inputs that they could provide. That a proportionate response, and that the definite collective decision-making of all of those who are part of the ICB is the default position. Next slide, please. The exception to the rule, where it will need a bit more thought in future, is where there's a formal procurement of services. As I'm sure everyone will be aware, the provider selection regime is still not published, is not yet available for scrutiny, but that new regime, when it replaces the current procurement regulations for the health service provider procurement processes, will have its own separate rules, and those will need to be considered separately. But involving oneself in scrutinising a procurement as the rules currently stand would introduce significant risk of legal challenge of an unfair process if one was to be marking one's own homework. Next slide, please. So the current thoughts on the entire process is that the NHS is a hugely complicated system with multiple working parts. The standard newspaper headline of the NHS is in trouble is one that everyone listening to this presentation will be aware makes a nonsense of the sheer range, diversity, and number of sectors, people, institutions, and organisations involved in delivering the health service. Throwing together the different parts of the service to form integrated care boards is part of a very long-term strategy of greater collaboration rather than competition within the sector. The underpinning thinking of collaboration as compared to competition means that the new environment of delivering healthcare services is one that has a slightly different mindset than has been predominant for some years. The differ, I suppose, from the establishment of the CCGs when they were first set up, was that primary care was kept with NHS England to avoid the sorts of conflicts of interest as the GP members of the governing bodies of the CCGs were clearly having a conflict of interest with commissioning local GP services. But over years that has occurred, and the delegations to them have occurred, and management and proportional systems such as primary care committees were created to consider and commission care from the GP sector by CCGs. The wider range of organisations involved in ICBs does create a wider potential for individuals to be at least accused of having a conflict of interest in any decision that they're making. The main guidance at present is that the ICBs will need to develop internal policies on conflicts of interests and standards of business conduct policy. Whilst those are being drafted, they will be the rules with which the ICB board and board members are expected to conduct the business, conduct decision making, and conduct procurements. Breach of those policies could be a matter giving rise to challenges to decisions made on the basis that you haven't followed your own guidance. As such, they'll need to be drafted quite carefully. There's potential for guidance or policies to get in the way of decision making if they're drafted in such a way not to give some flexibility to how matters go forward. Not everything can always be written down in black and white, and some things simply need to be thought of in terms of the test I referred earlier, the sniff test. The sniff test is another way of putting the private eye test or the Daily Mail test. If it's published on the front page of the Daily Mail and you can't justify how a decision was made because of the people involved in making it, you probably had a conflict of interest that should have precluded participation. If you can explain it and it doesn't cause a red face, then it probably has passed the sniff test and has passed the Daily Mail private eye test. Unfortunately, with any change there comes uncertainty. It's obvious that the ICBs are new. Making decision making in this collaborative arena is new. That mistakes will be made. That a few red faces may occur, but I don't think they will necessarily lead to flawed decision making or to wrong decision making. But there may be a line of legal challenges based on accusations of bias or conflicts of interest in decision making. But those will sit alongside the challenges that are perhaps par for the course within this incredibly complicated system. Last slide, please. So I didn't want to spend the entire presentation with slides and doing my Chris Whitty impression of next slide, please. So I will draw my presentation to a close there and invite comments, questions, or thoughts from either Lauren or hopefully those watching.
Thank you so much, Michael. That was great and really helpful. Yes, so we have received a question from Brenda. And the question is, what mechanisms are in place to ensure new declarations are made within 28 days?
Well, those will be set out in the duty under the Act is that the ICB must make arrangements to secure that occurs. It will be set out in the policy document, which sets out how it's done, but also in the standard format of decision making at board meetings. There'll be a requirement to declare, or anticipate all ICBs to make declarations at the start of meetings about their conflicts of interest, or if they perceive they have conflicts in relation to the matters on agenda at that meeting.
Yeah, absolutely. I think that's a really good point. So we certainly have on all of our provider boards and committees an item at the beginning of every agenda just to sort of prompt individuals. In terms of obviously the wider organisation and all of decision-making staff, I think it's a very difficult one. Almost you can't control it because you don't know who all of your decision-making staff, whether they're going to have a new conflict arise. But I think the key is just making everybody aware of what you have in your policy, and even sessions at induction can be quite helpful, and communications such as, you know, screensavers, just reminding people that I think within the 28 days it's that's the limit.
I think it's important to realise that not everything that might be an interest in a loose sense of the word might be a conflict of interest. That people can have involvements and actions, or organisations can have interests which do not necessarily lead to a conflict of interest, even when a matter on a related topic is being considered. You see occasionally individuals or having to decide where and whether or not they have a conflict, and discussing it in CCG or board level with the chair, and seeing, well, these are what is going on. Do you think I should be excluded? And making a pragmatic decision, often involving a form of the sniff test, although not necessarily referred to as that in any documents other than my slides.
Yeah, absolutely agree. I've got another question that's come in from Catherine. And she says, all fine within the NHS, but an interesting call in local government and elected members' loyalty interests to their political party and their electorate. Any thoughts on this?
Many. I think it's a sea change in the operation of decision-making involving local authorities which have a substantially different approach because of the nature of their accountability to the electorate, to CCGs or PCTs before them, or now ICBs, with an accountability to the Secretary of State and Parliament, rather more indirect democratic accountability. I think in a previous roundtable discussion, it was touched upon as a very different organisational attitude, and trying to find points of similarity in operation, and not tribalism. Now, in practice, that's going to be very difficult, if in some areas, I suspect, to put into place, where controversial, difficult decision making has to happen. The trite position is that no one wants to see, or no one ever supports, a service closing, but a service closing may be the correct commissioning or non-commissioning decision. That may be in the typical save our NHS type judicial reviews or campaigning. It's often the case that controversial issues are subject to a lot more scrutiny and overview and scrutiny committees, and in some areas there have been references, of course, to the Secretary of State and the reconfiguration panel, the independent reconfiguration panel, on points that are perhaps locally controversial. With local authorities becoming involved in and decision-making, voting decision-making parts of this, I think will be perhaps a challenge at the outset, but it's not something that could be addressed in either the Constitution or with law. Everyone is obliged to sit on the ICPs and ICBs, and to put the interests of the region first. That is what the requirement is. How it operates in practice is probably not going to be a matter of dead letter law, as opposed to personal interaction and objective decision making.
Thank you. We've got a couple more coming in now, which is really great. I'm glad to see so many questions. So we've got one from Karen, which is, with the nature of collaboration, there will always be people wearing two hats. So how do we protect staff whilst also encouraging them to bring their professional expertise to systems, discussions and developments?
In terms of protecting staff, I think that everyone should have their whistleblowing policies and their speak up guardians in post and be able to feel that they can express internally what's going on. Certainly, I don't think that it would be worrying, I think, if organisations or individuals felt unable to express views on what they consider to be system, what would be right for the system as opposed to organisation. I'm not quite sure what staff level the question has in mind, but I can't. I would hope that there would be no prospect of senior cardiologists in one hospital who think that change should occur, which may remove services from that hospital and centralise it somewhere else, perhaps, feeling that they couldn't say that it would be better done that way, notwithstanding that the trust may not have the same view as a silo organisation, but looking at it from a system perspective, that should be, in my view, a form of protected speaking. In terms of board members, they will who will be sitting or taking part as members of the ICB. I think that there'll be board members wearing multiple hats as organisation, as collaborative. Let's provide a collaborative hat, a organisation hat, an ICB hat. They'll already have involvement in Section 75 arrangements with system-wide hats for certain purposes, whether it's the Better Care Fund or other integrated arrangements that are already in place across much of the country. So wearing two hats, I don't think will be that new to anyone. But in terms of speaking up, obviously a firm policy is the best you could have. That would be considered not appropriate for reclamation, victimisation, or discrimination for having participated and put system first.
Yeah. I think it's a really important one. In a moment, I'd like to hear a bit more about, obviously, it from the provider board side of things, because I know, obviously, there's quite a lot of guidance out there, which seems to provider board trying to also update our own policies. But I just think we also need to obviously consider it all now in the context of, there's a duty to collaborate now, there's the AAA, and we also have to make sure the organisation contributes to the system financial balance. And therefore, in some ways, there's less conflict, because part of the responsibility of our boards and staff in running the organisation is actually making sure that we support these aims. So it sort of just brings a new element to it. I've got another question from Karen. And it's, how do you see the management of conflicts of interest interacting with directors' duty of confidentiality to an organisation?
With some difficulty in some respects. If it's not clear what information is being given to who and why, there is going to be the changes to competition law in due course about how passage of information may be in breach of areas there, but certainly information and how it's going to be guarded and processed and provided in some areas will be quite simple, and in some areas will be quite difficult. The one I've highlighted in this presentation is the clear line that will be on the procurement side, where if a procurement is underway or there is a provider selection to be done, it will not be appropriate, I don't believe, in all cases or in most cases, for those to whom are participating in a competitive procurement or likely to be the provider selected, to receive the information generated and passed out, as that may give rise to problems. The whole area of these conflicts and operational sides, especially information sharing across the organisations by virtue of participating within the ICB structure of decision making, is an area where I think there will be some benefit if there is more guidance from NHS England as what they expect ICBs to do, or B, the guidance and specifically the conflicts of interest and standards of business conduct policy, which all are being sort of strongly hinted at that you should have in place, clear on who should be given access and when and to what and for why and for what purposes. Traditionally, things have been dealt with where information is shared across organisations with things such as information barriers, agreeing who can receive the information and for what purpose they can then put it. There's a huge amount of information sharing that does take place of what might be considered commercial information across provider collaboratives, for instance. But most of those have agreements in place that I've assisted with, have got agreements in place specifically on information sharing and to what purposes it can be put, being clear that it's not to be used for purposes other than the purposes of that collaboration. So it shouldn't just be shared with the entire executive management team. Now, I have no reason to believe that anyone would be breaching that, but on the ground, I do not know what information is shared. But I know that everyone in the NHS to whom I've worked with over the years has taken both data protection, information governance, and information security very, very seriously. So I'd expect the same at the ICB level, with caution over what is being shared and for why, but not necessarily because of the presumption of all members participating in the decision making, not necessarily limiting that, save for the purpose to which it can be put. That's a long way of saying it's quite complicated.
It's very complicated. This whole topic's very complicated. We've got a really interesting one here from Kevin, actually, which is, are you aware of any successful legal challenges or judicial reviews to an NHS decision as a result of a conflict of interest?
No.
There we go. Short and sweet answer.
It's formed. I have seen it in judicial reviews as parts of the pleading, where things have usually found themselves where decision making has been in trouble, is where guidance or the law hasn't been followed on who has or has not been consulted. That's been the major target, or that there has not been appropriate consideration of equality duties in respect of a decision that's been made, along with broad sweeping attacks on conflicts of interest. Normally, the decisions have been framed in terms of either the wrong information has been taken on board, so inappropriate information, or that there's been a lack of information. As I said, it is my speculation. I did say it at the start, and I am a little bit speculating that this is an area I can see that if it's not well governed, and if the policies are not consistent with the intentions behind the ICB decision making, that there could be a line of challenges based on your own guidance on how you should operate if that is breached, because that is a line that is brought in a fair number of judicial reviews.
Brilliant, thank you.
Not always successfully, I should say.
We've just got a couple of minutes left, but so before we go, I've just got two little questions as well. Firstly, what guidance should we expect to see over the next coming months? And also, I sort of touched upon it earlier, but we've got lots of guidance about sort of the implementation of ICBs and what they should be mindful of. Are there any sort of really key areas you think provider boards need to have on their minds, and for us company secretaries who work with provider boards too? Okay,
so there's a huge number of times in the guidance that's been published to date on the ICS and ICB creation and the wider establishment of the new bodies, saying that further guidance will be published. In the notes, in the slides, I've already included the statutory requirement that NHS England must publish guidance on the discharge of functions by ICBs. So once that comes into force, and isn't in force yet, then NHS England will have an obligation to publish guidance on the discharge of functions. There's permissive areas within the Act about may provide guidance, but this one's directory and says must. In terms of provider collaboratives, key areas for thought. It was the key areas for consideration. Was it, Lauren, that you wanted?
Yeah, just any sort of key areas for consideration.
I think the key area for consideration is understanding what it is you're actually trying to achieve, and being relatively robust in documenting that. So that those involved actually, I think there is a slight tendency to not necessarily think about what it is you're trying to achieve, document it, and document who's decision making. I don't mean tying yourselves in knots and giving my colleagues, myself, and the other firms too much work in terms of the partnership agreements. There are good templates out there published by NHSE that setting out the principles of how you're going to make decisions, saying what's actually in scope for the decision making, and recording how decisions have been made. Because there has been a little bit of mission creep in some, or straying outside of where they were originally thinking of going, and people not having the same views on what it is that they were in fact getting in to do. So I think having a firm idea of what you want to do, but not getting too tied up in legal knots over how it is necessarily recorded, but making sure it's at least understood between those going into these things as to what it is you're attempting to achieve through them.
Brilliant, thank you. I'm going to wrap up the session now because we're just about on time. But I just want to say a huge thank you for your presentation and for answering the questions. It's been really, really helpful, and I hope everyone else that's been joining us has found it useful. And thank you to everyone that submitted a question as well, and of course to our NHS provider colleagues who have been keeping me in check in the background as well. We've got Michael's got his email address on there if anybody has any further up questions. And of course, we've got our company secretaries network, which is quite active in terms of emails as well. So please feel free to contact either of us through those means. And I hope everybody has a lovely day.
Thank you for joining.